Jack Smith and the government prosecutors are now telling Donald Trump and his defense team, you don't really need to read all of the materials, all the evidence and the discovery that we sent over to you. And it happens to be a lot. We know we've talked about this before. Trump's defense is asking for a trial date to be postponed to 2026. Why? Well, they told them that there's 11.5 million pages of discovery. Of course, in their filing, they said that this was 8 Washington monuments. And so I want to do a recap on what Trump's defense said. It justifies a continuation of a trial to 2026 because the government has responded and they're saying, you don't really need to read it all. Then we'll take a look at what's happening in Georgia because this is also a joke. They issued a $200,000 bond for an insurrectionist, and we'll see what Trump says about all of it. So remember that when Trump's people asked for a continuance, a very long postponement of the trial, they filed a 16-page motion. It was absolutely excellent, and we read through the full thing in a prior segment. But today I want to just remind us about the math that's involved. They say 11.5 million pages. It's a lot of pages, difficult to comprehend. Normally, a complex case might have 1 million pages at issue. To have over 10 times that against one defendant is so huge, it's largely unheard of. We saw other examples where Walmart versus Visa, okay, two of the biggest companies in the country and the world, took 7 years to litigate a case of 5 million pages of discovery, and Trump has more than double that. To put 11.5 million pages into perspective, we began downloading the government's initial production on August 13th. 2 days later, still downloading. We asked the government to send a hard drive. We got our technology vendor to start putting those into our files, and it's going to take several days to even process that. But, Judge, even assuming we could begin reviewing the documents today, we would need to do 99,762 pages per day to finish the government's just their initial batch by the date which they want jury selection, which would be in December. That is the entirety of Tolstoy's War and Peace cover to cover, 78 times a day, every day from now until jury selection. Big book. Keeping in mind, this is just to read the government's initial production one time, which obviously never happens. You never just read it once. To say nothing of trial counsel's need to analyze, organize, and integrate those into a cohesive defensive presentation. They said, look, Your Honor, I know it's a big number. Stated differently, if we were to print and stack 11.5 million pages of documents with no gap between the pages at 200 pages per inch, mashing those down like a ream of paper, the result would be a tower of paper stretching 5,000 feet into the sky. That is taller than the Washington Monument, stacked on top of itself 8 times with nearly 1 million pages to spare. So if they just delivered the pages stacked up, it's a full Washington Monument height, 8 times. That's a lot. And the defense needs to read all that. And they need to read it multiple times. And probably multiple people need to read it. This is one of the biggest cases, if not the biggest cases in criminal law history. It's the prosecution of a former president, current presidential candidate. It's insane. The eyeballs from the defense perspective have to be many. So it has been huge, right? And the rest of this motion details what a joke it is to ask them to not be able to review it. But the government has now responded, and they're not putting as much effort into this. They say, all right, 11 million pages, so what? And remember, that was only the pages. We don't know what audio they've got, what video they've got. Oftentimes there's spreadsheets with, GPS data, cell phone records, IP addresses, all sorts of scientific printouts if they do any analysis, or if you do like data drop from any technical devices. It's just log files that you can't even really paginate. It's just huge data drops. And you say, well, I've got to go through all this. And it's insane, right? It's just massive amounts of data, more than Walmart versus Visa. And Trump's people got to go through every single bit of it. And the government now can't come out and say, oh, sorry about that. We accidentally included 11 million of pages that you don't need. Like, that meatball is out there. We all know you got it. So here is Jack Smith responding. He says, all right, here's the government's reply to Trump's response about the extension of the trial date. They say, Jack Smith and our lawyers reply to aid this court in setting a fair and prompt trial schedule. They want jury selection to start at the end of this year. In service of a proposed trial date in 2026 that would deny the public its right to a speedy trial, Trump cites inapposite statistics and cases, stuff that is not applicable here, overstates the amount of new and non-duplicative discovery, so a lot of those pages are just duplicates, and exaggerates the challenge of reviewing it effectively. What, can like prosecutors read faster or something? Are you guys so much smarter? For the reasons below, neither the discovery nor any other factor raised by Trump and his defense impedes a fair trial on the schedule proposed by the government. Your Honor, they can read Tolstoy's War and Peace 7 times every day. It's just 100,000 pages. They say, all right, Your Honor, we're going to take this apart for you. Trump made some comparisons to the schedules of other cases like Walmart versus Visa. They say Trump references different statistics and January 6 cases. When he references those, they really overlook the important underlying facts and context, Your Honor. Remember, let's clarify this for you. First, Trump cites the median time from commencement to termination for jury trials, which is 29.4 months. Long time. They want this to basically be done in 5 months. A little bit different than 29.4, without explaining that this median time runs through the completion of sentencing, not the beginning of trial. Okay. All right. So what, you want to take off a couple months for sentencing? So what they're saying is, yeah, like from the arraignment, the initial court date, all the way up until the jury selection is one time. But then jury selection might take 2 weeks, and then the trial might take 6 weeks, and then you might have a conviction, and then you might have sentencing, which comes back in 3 months. And so if you include, what, 6 more months, that is the inappropriate measurement. Okay, that's fine. So take 6 months off, 29.4. All right, let's do the math on that. I think that's 23.4. And if you calculate 23.4 and you say, is that longer or shorter than what they're asking for Trump, which is about 4.5 or 5 months? Not even close. Even for a lawyer who can't do math. That means that it includes the time required for jury selection, trial, verdict, and several months or more after and before sentencing and final judgment. Okay, fine. So what? Subtract 6 months. It's still insanely not even close. The question here is when it is appropriate to start trial in this case. And statistics regarding the length of time from indictment to sentencing have no bearing on that decision. Okay, that's fine. So just go from indictment to jury selection. Just narrow the scope a bit. And what is that number, government? Even if we give you that, like we'll give it to, what do you want, a year? Do you want to take like a full year off? Which would be insane, right? That's like probably 5 times more gratuitous. Then you would still say 13 months is appropriate. Second, they say, so they're just making stuff up. This is like one of the worst arguments you've ever even seen. What are they talking about? They're going to buy themselves 6 months after somebody's convicted for a trial and then say that makes things fair? Second, the data cited by Trump spans October 2021 through September 2022, when federal courts had a backlog caused by COVID closures. During that period, only 22 cases went to trial nationwide. Well, we're about to get it back into, I think, Biden's talking about new whatever. The small and skewed samples provide no help to the court in deciding an appropriate trial date. So first of all, they measured it wrong. And number two, they measured the wrong era because of COVID. I'm very doubtful that is the actual reason why those trials were delayed. Okay, remember, Visa versus Walmart was 7 years. They went through a full COVID because they had 5 million documents. Trump's got over double that. Trump listed January 6 cases when he was also making his arguments, but they also omit important details in context. Trump fails to mention, for instance, that the one case he cites, the disposition was delayed because, among other things, there was litigation over pretrial detention. There was a superseding indictment. There were plea negotiations. In other words, there were reasons why that case took so long. And the other January 6 cases, they included multiple co-defendants. So this court should then just set those aside, right? Those don't matter. Don't think about their cases, because you do the old compare and contrast. You say, well, I mean, if you think it should go this way, let's look at this case and this case and this case and this case, and why was this one not like the others? So they're just saying, just don't look at those. They're bad examples. The court should set these comparisons aside when weighing the individual factors because we can distinguish them. So their measurements are all wrong. Now, let's talk about their disclosure. So they say the government respects the defendant's need to review discovery and to prepare for trial. That's good because that's pretty important. Due process, things like that. But Trump's characterizations of the volume of discovery miss important facts. The majority, or roughly 65% of the government's first discovery production, in which the government front-loaded the most important materials, consists of materials to which Trump has functionally had access, are duplicative, or do not constitute discovery under our rules that we have to disclose. So they're saying, in other words, they're just copy and pasted paperwork. It's just duplicative. Or Trump could have gotten these materials. He had access to them before. 3 million pages of the discovery, 25% of the first batch, come from entities associated with Trump. So they're like, they came from him, which I don't know why that matters at all. So he should have been reviewing all of his own stuff to know what you were combing through to create a crime against him. Obviously, he's got to review what you've taken and what you've assembled. They say on August 19th, a footnote, they say the government made a smaller second discovery production consisting of another 615,000 pages or files. Approximately 20% of this production was again generated by records from an entity associated with Trump. So they say it comes from him, therefore he doesn't need to read it, even though it has been seized and processed by the government. Would you take that? It's like the government takes all your stuff, reviews it, says we're going to use this stuff against you in a criminal case, but you don't need to read it again because you already had it. So you already should have known about it. So you don't need to look at it. You say, well, I want to look at it. There's not enough time to look at it. So I need more time. They say, no, you don't need more time because you already had it. So you could have already looked at it. So therefore you don't need to see what we have created against you, which is like, I can't even imagine. It's amazing this person has a law license. Hundreds of thousands of other pages came from the National Archives, a government entity, meaning that Trump or his defendants reviewed them before the government received them. They looked at these before they turned them over to the National Archives, and then the government got them from the National Archives, and the government's going to scrape those for evidence to use against Trump, and Trump, again, doesn't need to read that because they read it on the first round. Or these are publicly available, including Trump's tweets, his Truth Social posts, his campaign statements, his court papers involving different election challenges by his defendants and allies. Nearly one, again, all of those things. You still have to look at those. You still have to read them and analyze them and fit them into your case because you have to deconstruct what the government is doing with it all. You don't just get to say, oh, okay, so they're using all of this evidence against me that I already had, so therefore I don't need to review it. It's like malpractice. Nearly 1 million more pages came from the House Select Committee, which was illegally constituted and not really worthy of an investigation at all. Hundreds of transcripts or interviews, depots, and a majority of which are already public in redacted form. They could have reviewed them. Well, so first of all, they didn't know that they needed to go read all of those things. Trump had not been indicted yet. So that's great that they're all available, but you still got to read them and you still need time to read them. The fact that they were there and available, they're like blaming Trump. Well, you should have been reading all of this. You should have known about it. Well, you didn't file charges. And we're not going to just read everything with the prospect that we might identify some things the government is going to use to charge us. No, they've got to tell us what they're using so that we can investigate that. It's their burden of proof. They have to generate the evidence. They present their case and we respond to it. We don't have to have the burden of preparing our defense in case the government decides to file charges. We're like, oh, perfect. We were reading about this. The first discovery production included more than 100,000 pages of duplicative material because the government sought to produce it in, listen to this, it's like a high school kid. No offense to high school kids. Sought to produce it in an exceptionally organized, clear, and user-friendly fashion. So you've got some prosecutor dorks out there organizing spreadsheets with labels and color coordinated into rows. You're like, wow, it's all nice and labeled with folders. That's why there's 100,000 pages of duplicates? Doesn't sound very organized. For example, if the government obtained a record and then showed it to a witness during an interview, the government record would appear twice in discovery. The first clearly linked to a source from which the government obtained it, and the second in a clearly marked witness interview folder. The record would appear twice in discovery. Okay, well, somebody's got to read them to make sure they match. I mean, there's a key component of evidence. It's called prior inconsistent statements. If you have any aberrations, if one thing doesn't match another, that's a big problem. Somebody said something on this date and it changed on another date. One report says this, another report says that. DUI results say this from one person and they say this from another. It's a big problem. So if it's in there twice, you got to read it twice, even though they're saying it's nice and organized, but it applies to this person. I got to think about it, how it relates to this person. You know, the alternative would just be to not link, like you'd have just one document bin and you'd have the notes that reference the document. And if everybody references the same document, you don't duplicate the document. But I see what they wanted to do. It's nice they did it. Guess what? The defense doesn't give a crap about your nice organization skills in your rigged, fake, illegitimate prosecution against your political opponents. Don't care about your labels. In addition, the government took on the task, this person is so proud of themselves, of providing the defense a set of key organized documents that the government views as some of the most pertinent to its case in chief. These are tactics that we're going to be using, and this is why you only need to review this stuff and not everything else. These include certain key grand jury transcripts and other exhibits cited in the indictment. That's great. That's great. We want all of the grand jury transcripts and all of the exhibits and enough time to read it all. In addition to the keys, the government says, in an abundance of caution and transparency. And you know, when they say stuff like this, when you hear people tell you that a war was illegal and unprovoked, you know, when they say that like a billion times every day, something like that, you know, well, maybe I got to think about that. Was it really illegal and unprovoked? You know, something like that. So same thing's happening here. Exceptionally organized, right? We've gone through in an abundance of caution and transparency and all this stuff. You go, all right, they're fluffing this up, which means it's probably a disaster, which means there's probably a bunch of hidden evidence and they're trying to obfuscate this thing and you can't trust them for a minute. The government also produced voluminous materials that are not likely to fall under discovery rules like or Brady or Giglio. So they're over disclosing, and which should not require substantial time or attention from the defense team. Oh, that's good. So the government just says, you guys can skim this part. Yeah, no, just skim over that. No, that's not important. Is this? No, that's not important either. It's definitely not exculpatory. You guys don't even need to read it, which is encouraging the defense to commit malpractice. just gloss over it. For instance, the government received from the Secret Service 3.1 million pages of material, including all emails in a given period of time from a number of custodians, generating a large number of irrelevant and duplicative records. Okay, well then why are they included in this discovery? We don't believe you that it's irrelevant and duplicative. And my friends, remember, this is their disclosure. The defense is going to review everything and say, hey, we need supplemental discovery on this. I mean, this person in this report said this thing, and I need to know more about that. So it says you also had a conversation with him, and that's not in this disclosure, so I need to go get more. Please go back and get all of it, which is why you look through all of this. It might be irrelevant to the government, but it's definitely not irrelevant to the defense. We're asking the next question, or the next three questions. What is that report going to reveal? Who's that person who wrote it? Who's that person's boss, and why did it happen that way? Who approved this, right? And the whole thing. The government provided these materials in load-ready files so the defense can review them quickly, and in the same manner the government did, through targeted keyword searches and electronic sorting. That's really neat. So they're saying that we should use their same tools. So they just search for a couple phrases like, insurrection or steal the election or, Mark Meadows or whatever. That's all they needed to do. So the defense can just do the same thing, which is obviously insane. The defense is not going to do any of that. The government has the orientation of prosecuting. The defense has to defend, which means we can leave no stone unturned. We've got to find everything. They just dump a bunch of files in and they craft a narrative, and it's a whole different type of conversation. It's a different practice entirely. They say, indeed, the government provided the discovery and organized load-ready files for importation into searchable electronic database, with the understanding that the defense, consistent with modern standard practice, will review discovery electronically rather than manually. All right, but it's all of it. The defendant's filing confirms that he intends to use a document review database. All right, and they say here, Trump's proposed trial date, however, rests on the faulty assertion that it is necessary for a lawyer to conduct a page-by-page review of discovery for a defendant to receive a fair trial. Oh my gosh. It's just incredible. It's faulty assertion. All right, you lawyers. You don't need to review a page-by-page review of discovery for the defendant to get a fair trial. Meaning that they are asking the judge, this is a disgusting thing, they're asking the judge to basically order the trial, knowing that it's impossible for the defense team to review all the discovery. It's a faulty assertion that the evidence needs to be reviewed by the defense in order to have a fair trial. The trial can be conducted still fairly, even if the defense doesn't review the evidence. This is your Department of Justice speaking here. Unfortunately, it's the government's. And I know many people on their side will say this is totally legitimate. You can just, why do you even need a trial for? Really? Do you even need to review the evidence? But Trump can and should and apparently will adopt the benefits of electronic review to reduce the volume of material needed to be searched and manually reviewed. These methods include efficient keyword searching and relevancy tagging by multiple simultaneous users, as well as date filtering and deduplication and threading, all of which services are offered by their e-discovery vendor, and according to its own website, they are tools in courts that legal professionals use. That's fine. That's true. That is true. For like, I don't know, a couple thousand pages of documents, a couple 10,000 pages, not 11.5 million. This is all true. Yeah, that's all true for normal cases. But the volume here is insane. Department of Justice and Administrative Office of Courts, they're referencing this. They say that Trump also contends, Jack Smith speaking, that the existence of classified discovery necessitates delay. But this is not a case about classified information, and the government does not anticipate introducing classified material in its case in chief. It doesn't matter. Trump still has to review it. There's still the CIPA processes. The government is thinking very much from their perspective. This is all we need in this case. We don't need all this stuff. We don't need to review all of it. We didn't need to comb through everything in order to parse out the things that we need to secure a conviction. Therefore, we didn't need it. Therefore, Trump didn't need it. As the government will explain during its hearing on August 28th, there is no reason the CIPA process should delay this, and they're going to make the argument that Trump and his lawyers are already going through this in Florida, which is why it's not necessary here. The government says, in cases such as this one, the burden of reviewing discovery cannot be measured by page count alone. Man, they really hated that Washington Monument graphic. And comparisons to the height of the Washington Monument and the length of a Tolstoy novel are neither helpful nor insightful. I thought it was very helpful. I didn't realize that it was going to be 8 Washington Monuments. I mean, I've seen the Washington Monument several times. It's very tall, very tall. So to have 8 of those, I don't even know what that would look like. In fact, comparisons such as those are a distraction because they make the government look like idiots, which is determining what is required to prepare for trial. To accomplish that, the discovery should be measured by its relevance, its organization, and their labels, accessibility, searchability, and reviewability. Here, the government has organized and produced the materials in a manner designed to ease and expedite Trump's review, which allows trial to proceed as quickly as the government has proposed, which is starting in December. They say Trump contends the government's trial date also conflicts with his other trials, but the government is confident the court can and will adjust its own calendar around the other trials. For example, Trump points to the government's proposal to start jury selection in December. Conflicts can be easily addressed. We'll just move the dates around. In addition, Your Honor, setting a schedule in this case with deadlines for various disclosures can address other concerns. We agree with Trump that the court may order the government to identify exhibits well in advance of trial. We're prepared to do that, and we can comply with other advanced deadlines as well. We just want to move this forward expeditiously and fairly. Through reasoned discretionary scheduling orders like these, the court can fairly administer the prompt disposition of this case. From Molly Gaston. All right, so this name is going to continue to stand out because, wow, this is just a terrible breed. Like, terrible. This is basically saying, I'm an entitled, whiny prosecutor, and we got everything that we need in the way that we needed it. And yeah, we were too busy salivating, being focused on just burying Trump with dog piles of evidence. That we were just Hoover vacuuming up everything, just sucking it up and just putting it all into a big file, because part of their plan was probably to just dump it on Trump, as they have obviously done. And Trump, I called them out, really embarrassed them, I think, with this. I think they bit off more than they can chew. They've got 11.5 million documents in an initial trove of materials. And what is the judge going to do? Deny Trump the right to access and review the evidence? Very well could. We'll see what she does, but this is actually shocking to hear the government say that the defense should just trust their judgment. We organized things. We labeled everything. I'm sure Molly was staying up late on Saturday nights, with her sticky notes and highlighters and organizing everything just so Donald Trump could have a fair shake in this election. And this is them now basically saying that Trump's team should commit malpractice and they shouldn't even review the evidence, and the court should just schedule it regardless, because 8 Washington monuments is, not a big deal. Kind of a reasonable thing. Now, the judge will issue a ruling on this, and we'll see what she says. Meanwhile, in Georgia, we know that Donald Trump has agreed to post a bond. And this is very curious because we know that Donald Trump is being charged with a lot of very serious crimes in Georgia. Big Fanny, very upset. Not only is Trump charged, but also 18 other co-defendants, because they almost stole the country out from under us. And so for some reason, they're not really reflecting that in their consent bond. This is curious. Filed on August 21st out of the clerk of the court from Fulton County, a consent bond and order for Donald John Trump. Now, this is strange because, there's a bunch of other January 6th defendants who are all in custody, and they have gotten no bond at all. And this is the 4th indictment for Donald Trump, and he's about to walk out on all 4 of them. Florida, there was no bond. New York, there was no bond. The DC January 6th case, no bond. Was released on personal recognizance, just walked right out of there. And this is curious because I thought he almost stole the country out from under us. Why are guys like Enrique Tarrio facing decades in prison? Why, when they were not even there on January 6th, they were the organizers, right? Stuart Rhodes, same thing, the organizer of the insurrection. They're in custody. They're looking at decades in prison. It makes your stomach churn. But these people who told us that Trump led the whole thing, every time push comes to shove, every time they have their opportunity to lock him up because no one's above the law, with their hyperventilating, screeching from the rooftops everywhere we turn, now's their big debut. Lock him up. No one's above the law. And they do a consent bond for $200,000, which he can drop 10% on. It's tip money. It's nothing. Here, look at all these counts. $80,000 for the RICO, criminal solicitation, conspiracy, all 10 a pop, big deal. $200,000 for Trump, a billionaire, with 10% down, and he goes free. Is this a joke? I thought Big Fanny came out and was basically, hyperventilating from that podium. Ooh, screaming at everybody about how horrific this was and how they've been investigating this for years and how important it was. Trump flips him a black chip. Here you go. Here's your bond. And it's nothing. And he walks out the door, which is a very concerning thing frustrating because, we certainly don't want insurrectionists running around this country. But for some reason, 4 different judges have not had these stones to match the language. The government's not even requesting it. They're not even asking for anything. They didn't even ask to hold him in custody one time. Now they got a $200,000 bond. At least they asked for a bond here in this one. Slightly a little bit more, but not the others. It's like a joke. So something doesn't match. Their words don't match their actions. Why? Because their words are fake. They're just fake. Consent bond order. The above caption matter here coming before the court with consent of counsel for the state of Georgia. The big talking, bloviating Georgia prosecutors, Trump. They agree to it. The court hereby grants and orders that the bond is set in this matter as follows. Now, and he may post as cash. Don't know if he's going to do that. Or he can, they have like bail bonds programs where you can post an amount and the bail bonds company will cover the rest of it. So he can drop 10%, nothing. They say that Trump shall not violate the laws of the state. Very standard release condition here. Laws of any other states, okay, remain law abiding. That's the law. That's in every single term. The defendant shall appear in court as directed by the court. Okay, also very standard, nothing new there. The defendant shall perform no act to intimidate any person known to him or her to be a co-defendant or witness in this case. And now we have a question. What is intimidation? Can he call them out by name or to otherwise obstruct the administration of justice? And now we've got a very serious conflict here, as per usual. Trump's free speech, Trump's right to express himself in the middle of a political campaign. Political speech is the most protected of speeches. And if we have comments about any of this stuff, maybe government witnesses who might be involved in this, is that intimidation? Is that obstruction of the criminal courts? Or is that just his free speech in the middle of a campaign? They say Trump shall make no direct or indirect threat of any nature against any co-defendant. Now, the left, if Trump says, I think I'm going to go have a sandwich for lunch, they think that's insurrectionary language. Oh, where's he going to lunch? What kind of sandwich? White supremacists like sandwiches. Yeah, that's a very turkey, probably, huh? Yeah. What, with mayonnaise? So then they freak out about it, and it's an indirect threat. It's like a dog whistle. MSNBC does cartwheels. So this is going to be a very clear distinction. What is free speech? What is a direct or indirect threat against any co-defendant? They say the defendant shall make no direct or indirect threat of any nature against any witness, including individuals designated in this indictment. So it's a threat. Like, it's not saying don't mention them by name because that would be overly broad. That would obviously be impinging on Trump's speech, but here a threat, okay, well, you can't threaten anybody or witness tamper anyways. Like, that's all obvious. Like, you can't threaten people, but not limited to the individuals designated in the indictment. The defendant shall make no direct or indirect threats of any nature against the victim. All right, any victim. Who is that? Georgia? The defendant shall make no direct or indirect threat against any nature of the community. No direct or indirect threat of any nature against the community or to any property in the community. That is a broad term. I don't even know what that means. Like, can't talk badly about Big Fanny? We'll see what that is. The above shall include, but not limited, to posts on social media or reposts of posts by other individuals on social media. And again, Trump, in my opinion, I've not seen direct or indirect threats of any nature. He's commenting on cases. They take a sandwich order as a direct threat. They say the defendant, and we'll see what Trump says on social media because he posted, the defendant shall not communicate in any way, directly or indirectly, about the facts of the case with any person known to him to be a co-defendant in this case, except through his or her counsel. Next page, it is Trump shall not communicate in any way, directly or indirectly, about this case with any person known to be a witness, except through his lawyer. Ordered 21st of August, 2023, Scott McAfee, Judge, Fulton County Superior Court. Signed by Big Fanny Willis. Yeah, that looks like a Big Fanny signature. We got Drew Finling, counsel, Marissa Goldberg, and Jennifer Little, all representing Donald Trump. And so, very standard order. I mean, it really embarrassing for them. It's shocking that they have buckled so easily and so cheaply. I mean, $200,000? It's like nothing. And they said Trump was wrecking America, literally. All right, so Trump posted right away, obviously. He responded August 21st at 6:55 p.m. after the order was entered. The order was entered at 3:30 p.m. Trump posted truth right after that order, 6:55. And remember, he's not supposed to badmouth that community on social media. Here's what he says. The failed district attorney of Fulton County, Atlanta, Fannie Willis, insisted on a $200,000 bond for me. I assume, therefore, that she thought I was a, quote, flight risk. I'd fly far away, maybe to Russia. Share a gold-domed suite with Vladimir, never to be seen or heard from again. Would I be able to take my very understated airplane with a gold Trump affixed for all to see? Probably not. I'd be much better off flying commercial. I'm sure nobody would recognize me. It's just such a ridiculous thing. A $200,000 bond is just a joke, right? It's like actually a joke. And he knows it's a joke. Yeah, $200,000, that's going to stop him from fleeing, right? A bond like that is supposed to secure your appearance. It's supposed to mean that you don't run away lest you forfeit the bond. So Trump's just laughing at it. He's mocking it. Yeah, okay, your $200,000 is like one flight. I'll go hang out with Vladimir in my gold dome suite and I'll never come back. What are you going to do, Big Fanny? Nothing. So Trump is just laughing at it. He's just mocking it because the whole thing is a monster joke. They told him, don't you post on social media. Don't you badmouth us in any way. He just jumps right on there right after the order is entered. See you on Thursday, he says. All right, my friends, we'll continue to cover. Thank you for joining and following along and subscribing as we do.